So welcome. And before we begin the webinar, there are just a couple points I'd like to draw your attention to. On va enregistrer l'appel. We will be recording today's call. Tout le monde sera en mode muet pour cet appel. Everyone is on mute for the webinar, so we cannot hear you or see you. So no need to worry about barking dogs or family members. And but you will be able to participate in the call by using the chat box. So throughout the call, please type your questions or comments into the chat box, which you will find underneath the video. Veuillez utiliser la fonction chat box pour faire un commentaire ou pour poser une question. Pour trouver la fonction de chat box, déplacez votre souris au bas de votre écran. Et s'il vous plaît, n'hésitez pas à poser vos questions ou faire un commentaire dans la langue de votre choix. And you can also ask anonymously. There's a little checkbox there that should allow you to do that. And a reminder that questions should be focused on COVID-19 related issues. For technical issues, if you experience any technical problems, please click the tech support button, which is underneath the description section on the website, on the webinar platform. Si vous avez des difficultés techniques, vous pourrez le communiquer en utilisant le bouton tech support that you'll find at the top of your screen. And just a quick note about the partnership. The COC is delighted that Fasken is the official law firm of the Canadian Olympic Committee. This is a 5-year partnership primarily focused on providing value directly to the sports system with value-in-kind legal services. And the partnership includes 4 core elements: webinars such as this one, co-op calls, customized direct to NSO legal support, and a portal populated with tools, resources, and FAQs. The Fasken COC partnership was originally scheduled to begin in 2021, but given the COVID-19 pandemic and some of the legal issues that NSOs and of course athletes are struggling with and navigating right now, we accelerated the launch. The objective of this offering in 2020 is really to assist you and the broader system with recovery from the COVID-19 pandemic. So let's get underway. Fasken will be making a presentation followed by a question and answer period, which you can ask through the chat box. And our host today will be Marc-André Fabien. Marc-André is based in Montreal and is a senior partner and has been with Fasken Martineau since 1982. And he is recognized for his consummate grasp of complex litigations frequently under the media spotlight. And he has pleaded before all levels of courts, including the Supreme Court of Canada, the Court of Appeal of Quebec, the Federal Court of Appeal, and the International Court of Arbitration for Sport. Marc-André has also been involved in Paralympic sport for more than 20 years as a fundraiser, a board member, a fan, and a huge supporter of athletes and the movement, and is the current president of the Canadian Paralympic Committee. Marc-André, please take yourself off mute, and the floor is yours.
Hello everyone. Il me fait grand plaisir au nom de l'équipe de Fasken de vous souhaiter la bienvenue aujourd'hui. Plusieurs d'entre vous me connaissaient déjà pour les raisons que Tom a expliquées auparavant. Some of you know me already because today I'm wearing 2 hats. First of all, as Tom mentioned, I'm the president of the Canadian Paralympic Committee, which explains that I'm wearing the team jacket. But also today I'm here in another capacity. I'm here as a Fasken lawyer, as a Fasken partner, and that explains the bow tie. Fasken has been for the last decade a sponsor of the Canadian Paralympic Committee. Et aujourd'hui, Fasken devient aussi le commanditaire du Comité olympique canadien. Over 800 lawyers, Fasken lawyers, over 2,000 Fasken employees, I can tell you, are thrilled, delighted to see our law firm becoming the sponsor of the Canadian Olympic Committee. Fasken is a national law firm located in 7 different cities throughout the country, and we have 2 offices abroad, London and Johannesburg. We are a full legal service law firm, so we can offer services in almost all various domains of law. Pour nous, chez Fasken, c'est un honneur extrême d'être associé aux meilleurs athlètes canadiens, aux meilleurs athlètes au monde. As a firm, we feel proud and deeply honored to sponsor what we call Team Canada, our two teams, Olympians and Paralympians. Why? Because you, athletes, you are the pride of this country. Not only on our soil, but abroad. You are the unique ambassadors of Canadian values, and we are extremely grateful to all of you for that. Now, let me explain to you what will be the various topics that will be covered by our various speakers today that are all Fasken lawyers. The first topic, le premier sujet qui sera abordé par nos conférenciers porte sur les subventions données par le gouvernement fédéral. Y avez-vous droit? Are you eligible to the federal subsidies? And this topic will be covered by two of my colleagues, David McDonald. David McDonald is with our Vancouver office in labor law. David McDonald est un de nos collègues en droit du travail du cabinet de Vancouver. Et mon autre collègue qui traitera également de ce sujet, the other colleague that will speak about this topic is Raphaël Bouriana, who's going to speak about also the same subject. Second topic that we will be addressing today will be covered by Arif Chowdhury from our Calgary office, Insolvency Group, and also Julia Kennedy from our Ottawa office. She is in corporate, and the team is your sponsorship agreements. Le sujet qui sera traité par Arif Chowdhury et par Julia Kennedy est l'impact de la pandémie sur vos contrats de sponsorship de commandite. Le dernier point qui sera abordé le sera par Aaron Porter. The last subject will be addressed by Aaron Porter, and the topic is what comes next. Le sujet sera quoi après la pandémie. A short word about Aaron because she deserves, should I say, all the credit for this association between COC and Fasken. So thank you, Aaron, to have been the key player for us in that great association. Alors, sans plus attendre, je cède la parole à nos conférenciers. Now, the screen is yours, David and Raphaël.
Merci, Maître Fabien. Bonjour tout le monde. As Marc-André said, my name is Dave McDonald, and I practice labor and employment law in Fasken's Vancouver office. And Raphael and I are going to cover 4 federal programs that were instituted in response to the pandemic and how it's affected employees and their income over the past couple months. As well, Aaron will speak to athlete trusts at the end of our presentation. So the first benefit or program that we're going to speak to is the Canada Emergency Response Benefit. This was one of the first programs that the federal government instituted in response to coronavirus. It was announced on March 25th. And it was actually enacted that same day by a special sitting of Parliament. The CERB is a taxable benefit that provides $2,000 every 4 weeks or $500 every week for up to 4 months to employees who lose their income as a result of COVID-19. And in effect, this program replaces employment insurance for the period of March 15th to October 3rd, 2020. And as I said, this was one of the first measures that the government instituted in response to the pandemic. We'll move on to the next slide. So who's eligible and what are the requirements for the benefit? The CERB is available to employees or workers who meet the following requirements. First, you have to be resident of Canada. There's a minimum age of 15 years old. There's a requirement that you have stopped working for at least 14 consecutive days because of COVID. So you've been laid off, or your office has, your business has shut, your employer has shut, and you've had 14 days off. Or you're eligible for regular employment insurance benefits or EI sickness benefits. So EI sickness benefits are also known as EI medical leave. The CERB is not available to anyone who's voluntarily quit their job. So it's the same as employment insurance in that sense. So you can't quit your job just to go on to the benefit. And you have to have had a minimum threshold of income of $5,000 in the 12 months prior to your application, or $5,000 in the year of 2019. So that threshold is different than the qualifying threshold for employment insurance. So some of you may know that you have to work a certain number of hours and have eligibility for employment insurance. That's not the same case with the CERB benefit. CERB also allows employees to earn up to $1,000 per month while they're collecting that benefit. But you need to be careful that if you're in receipt of CERB benefits, that any income earned that's greater than that $1,000 in the month that you're collecting CERB benefits, that amount could be subject to repayment. So if you receive employment income that's greater than $1,000 and you're receiving the CERB benefit, you will be liable to repay that. And just a point, if you're an employee of an organization that has applied for a supplementary unemployment benefit, so this is a top-up program, another program that we're not going to cover today, but if your employer has SUB benefits, you cannot put those on top of the CERB benefit. So you have to be careful about that $1,000 threshold. Moving on to the next slide, this application. So as I mentioned, this program will replace employment insurance between March 15 and October 3rd. This replaces regular employment insurance. So employees who are off on a different type of employment insurance, like a maternity or parental leave, those benefits will continue. But for regular employment insurance and medical EI, the CERB is intended to replace it. So how does someone apply? You can apply through the Canada Revenue Agency website. There's also the ability to apply for this program by telephone. It's a very popular program. Millions of Canadians have applied for it. And because of the volume of people applying, there are specific days of the week that people can apply for the benefit. And those days of the week are allocated by your birth month. So if you go onto the CRA website or canada.ca, you can find information about when and how you apply and what days you make your applications on. We're into the program. So the program was announced on March the 20th, or enacted on March the 20th. It was retroactive back to March 15th. We're actually probably into the third benefit period, not the second, as the slide says. So the current eligibility period is May 10th to June the 6th. And if you apply and you already have a direct deposit arrangement with CRA, you can expect to receive this benefit within 3 business days. So they do expedite payment for those people who already have direct deposit. It takes a little bit longer if you don't have that already set up. So this is a taxable benefit, and this is an important point for everyone listening to keep in mind. You need to ensure that you claim CRB payments when you fill in your 2020 tax return next year. And CRA has said that they will be doing payroll audits to ensure that what applicants have said when they apply for the benefit match what the employer payroll records say. And so that $1,000 income threshold will be monitored, and claimants who have exceeded that $1,000 can expect to have to repay the benefit. Income of a provincial nature, so any person in receipt of provincial income assistance may also have to repay the CERB. But Tom Hall has advised that Sport Canada has indicated that the AAP program, the Athlete Assistance Program, or the carding income that you enjoy, is not considered income. So it doesn't count towards that $1,000 threshold that is subject to repayment in a CERB. So that is a very quick summary of the CERB. I'm going to turn it over to Raphael, and he's going to discuss the next program.
Thank you, David. Good afternoon, everyone, or good morning, depending on where you're at right now. So I will be discussing the Canada Emergency Wage Subsidy, or CEWS, which translates into French in Subvention Salariale d'Urgence du Canada, which is a kind of a hot topic. So if we can move to the next slide. The CEWS was announced on April 1st, 2020 by the federal finance minister. And it was a response to a lot of employers having laid off massive number of employees ever since the COVID outbreak in the mid-March. And in order to keep or to protect employment, the government is providing employers with a monthly subsidy of up to 75% of the employee's salary, wages, and other remunerations, in order to allow employers to keep the employees working or to keep them on their payroll and not have them benefit from the CERB, for example. So if we look at this program, it was supposed to be a 12-week program, and it was possibly longer. Now, last Friday, May 8th, Prime Minister Justin Trudeau confirmed that the CEWS will be available for a longer period. We have no information as to when this will end, but it was supposed to end at the beginning of June. We can imagine that it's at least another 4-week period, so until the beginning of July. So if we go to the next slides, there are essentially two requirements for an employer to qualify for CEWS and therefore receive a subsidy to pay for your salary, or if you're an employer, to pay for your employees' salaries. They have to be an eligible entity. We'll see what that is. And there's also a revenue drop test that has to be completed, and we'll also see what that is on the next slides. So if we move to the eligible question, so is your employer, or are you as an employer eligible for the subsidy? Well, you have to be either an individual or taxable corporation, a partnership, or certain nonprofit organizations and registered charities. So a lot of employers are encompassed in those criteria to be eligible. Those who are not eligible are generally certain public bodies, including municipalities, local governments, crown corporations, and university schools, hospitals. Specifically for athletes, NSOs are usually considered, or are usually RCAA's companies, and so those for those entities, it is unclear at this point if they are eligible or not for the subsidy. But the government is looking at clarifying it very quickly, because it appears to have been unclear from the start when they announced the criteria for eligibility. If we now look at the revenue drop on the next slide, so the revenue that a company or that an employer has to demonstrate in order to be eligible for the subsidy has to be at least a 15% drop in March 2020, or a 30% drop in April and or May 2020 as well. The reason for March being 15% and the others being 30% is because we technically lived a very happy and normal life until mid-March approximately, when we declared the states of emergency and where employers had to shut down. So the government is taking into consideration that a lot of employers would not meet the threshold if we asked them to have a 30% drop in revenues in 15 days in March. So that's the reason why March has a different threshold than April and May. And of course, that 15 or 30% threshold has to be analyzed in regards to a period of reference, which we will see in the other slides, but which will be either, for example, for March 2020, you would take either March 2019 or February and January 2020, add them divided by 2 to have a mean, and then look if the revenue in March dropped from 15% or if in April it dropped from 30%. So if we go to the next slide for the qualifying periods, it is similar to what David said about the CERB. We have qualifying periods, and if an employer qualifies for a period, then he is entitled to the benefits or the subsidy for that period, as well as the subsequent periods. That is in order not to put on a stress on an employer to say that he met the 15% threshold, for example, in March, but he won't meet the 30% threshold in April, so he may have to lay off new employees or recall some and then lay off others from month to month. So as soon as you qualify for one period, you can qualify for all the subsequent periods, you just can't go backwards. So there's the first period that was March 15 to April 11, the second one that ended on May 9th. So we are now as well in the third period, which is the May 20 period. If we go to the next slide, so we will see, as I said, the companies have a little bit of a leeway to make the calculations to figure out if they met the 15% or the 30% threshold in salary, in revenue drop. So either they can take the March 2019 period or the last 2 months till January and February, add them together and divide it by 2. This allows the companies a little bit more flexibility. If, for example, they suffered a massive loss, but last year was their first year, or for some reason March last year was a bad period, or if they have grown substantially since, to give a real number of revenue loss. So if we go to the next slide, there's specific rules that apply to nonprofit organizations and charities. These companies have a little bit, again, more of leeway and can exclude certain revenues from, for example, revenue they receive from government sources can be withdrawn or deducted from their revenues. So again, it gives them more and more of a possibility for them to fit in the criteria for this subsidy. If we go to the calculation, now this is a little bit of a tricky part because it's not a simple 75% of the employee's salary that's taken into consideration. That would be an easy step, but the government also took into consideration that at the time the subsidy was announced, a lot of employers had already put measures in place, including reducing salaries or reducing hours of work for many employees. So if we just took that amount that's already been reduced and we reduce it by 25%, for a lot of employees, it would be a difficult situation. So the calculation is a bit twofold, and you also have to take into consideration your pre-crisis weekly remuneration in order to allow you to get it more easily. And there are specific add-ons in respect of paid leaves. So for employees who are on paid leave, there's a little bit of there's a top-up to that's allowable for employees. If we go to the next slide, so who's an eligible employee? Well, that's pretty easy. If you are an individual and you are employed in Canada, you're usually allowed to get the subsidy as long as you didn't have more than 14 consecutive days of without revenue, in which case you would qualify for CERB. So again, you can't benefit from the CERB on one side, which is $2,000, and on the other side from the CEWS. Again, if you're part of a work sharing program, which is a program we're not discussing today, the benefits you receive from the work sharing program will be deducted from the amounts of the subsidy, so you can't add the two of them. And the remuneration includes essentially all your salary, wages, and other remuneration you can have. On the next slide, we have provided you with an example that shows that it's not, to show you that it's not as easy as saying that you're going to get 75% of your wages. There's a little bit of a calculation that has to be done. And employers have to take their best efforts to try to not reduce your salary up to only the 75% that you're entitled to, but also to give you the additional amounts that you would generally receive. So this is an expectation. It's not provided for in the law that they have to. It's strongly suggested that they do pay you the addition. And finally, if we look at the application, right now you were at the third stage of application, so we can apply for we can now apply for the April to May portion, which was the subsidy will be paid retroactively. And for the first period, it's already gone. You could apply from March to April. You could apply since April 27th. So that being said, I will now pass it back to David for the Canada Emergency Student Benefit.
Thank you, Raphael. And we'll cover these two programs quickly. They're designed to assist post-secondary students across Canada. The CESB was announced after the government saw the dramatic drop in employment for post-secondary students under the age of 30. Between February 2020 and March 2020, the number of students working dropped 30%. And so that dramatic drop led to this program being implemented. It's not in force yet, but it's a $9 billion income support for post-secondary students, many of whom rely on income over the summer months to help them in their studies over the winter and the fall and the spring. And it provides $1,250 per month for students who are eligible, or a greater amount of $2,000 for those students who have dependents or who have disabilities. Again, this program is provided by the Canada Revenue Agency. Today it was announced that the application process will be open this Friday, so Friday, May the 15th. And applications, the period of time again is May through August, but you can apply for the grant anytime before September 2020. So to be eligible, you have to be a student, you have to be enrolled in a program between December 1st and August 31st, or you have to be a recent graduate from a program. So if you've graduated from a program, received a degree or diploma, and you ended your studies after December 2019, you're eligible for the program. This also applies to those students graduated from high school this year, that happy cohort that will have their high school prom in their parents' garage. They're eligible for the CESB, and it also applies for Canadian students who are studying abroad. So in order to remain eligible, and we'll move on to the next slide, you cannot have income from employment or self-employment. You cannot be in receipt of employment insurance benefits or the CERB. So this is designed as a supplement for students who might not be eligible for the CERB. It's not designed. It's a replacement for CERB, not a top-up. Currently, international students are not eligible for the student benefit, and in order to receive the benefit, you need to show that you're making efforts to find work. So that's the CESB, and Raphael will speak quickly about the Canada Student Service Grant.
Right. Thank you, David. Yes, I will give you as information as proportional as what we have, meaning there's really not much to say here. Essentially, students can receive funding for tuition if they volunteer in a sector that needs assistance during COVID-19, because a lot of employment, as David said, for students is not available for the summer. So you can receive up to $1,000 to $5,000 depending on volunteer hours, but it is unclear how many hours qualify you to get how much money. So the program has yet to be confirmed by the government, and there's very limited information at this moment, including, and if we move to the next slide, it's very difficult to know how to apply, how applications will be assessed, the details, and how long it will take for them to be taken into consideration by the government officials. So it's very embryonic. There's a lot of information that we don't have. And that being said, I'm now happy to pass the microphone to Erin to discuss athletes' trusts.
Hi, everyone. Thanks, Raphael. A question has arisen about amateur athletic trusts and what the impact would be on eligibility for programs like the CERB if for people who have these amateur athletic trusts. And so the income that goes into a trust, as long as it goes directly into the trust, is not counted as income in the year that it is earned. So it wouldn't count towards the $1,000 threshold. And it's not counted as income until it comes out of the trust. Now, what this will likely mean, because it's not income from self-employment or employment, those are the types of incomes that the government is looking at when determining eligibility for CERB. It means two things. First of all, that you wouldn't be disqualified for CERB if you were withdrawing money from your trust. The second thing that it could mean is if the trust is the only form of income that you had in 2019, then it may mean that you don't meet the $5,000 threshold in order to be eligible for CERB. So it goes both ways, both that you don't have to count it towards $1,000, which would make you ineligible, but then also that you can't count it towards your $5,000 in income from the previous year, the way that the information is being provided right now from the website is written. So we just wanted to highlight that because this may be something that applies to many of our athletes. And I'll turn it now over to the next two speakers. So Arif and Julia are going to talk about sponsorship agreements.
Thank you, Erin. Hi, welcome to everybody. You can go to the next slide. Myself, I'm going to be speaking first, generally about sponsorship agreements, and then my colleague Arif will speak a bit more detail about two potential issues that COVID is bringing up directly in connection with all kinds of agreements, including sponsorship agreements. And then I'll talk a little bit at the very end about how we might think about approaching amending our sponsorship agreements or negotiating some changes given the new circumstances we're all in. Next slide, please. So just to take a step back, if you have a sponsorship agreement or more than one, then the basic architecture of it is that you as the athlete are being told by the sponsor that they will pay you, sometimes in a lump sum, through installments, which means at various points of time, potentially with certain conditions that have to be met before that payment gets made, sometimes up front, sometimes only after a certain event or milestone has been achieved. They can also be sponsorships not for cash, but for goods or services and other in-kind benefits. In return, you as the athlete are expected to perform some sort of services. This could be by wearing certain logos on your equipment or on your athletic apparel. It could be by you actually performing more direct marketing advertising activities for that sponsor. It could be for you to participate in a commercial campaign. It could be for you to use social media to promote that sponsor. And typically the sponsor is allowed to use your image in association with their brand in some manner in return for that payment. And then these contracts always have a limit to how long they're good for, either directly by having a specific termination provision or an end date in them, or sort of implicitly because your services will end at some point and thus the contract will have been performed. Next slide, please. So thank you. So some high-level common provisions that might be relevant when looking at this. You've got your payment terms. There's going to be timing and potentially conditions that you have to meet before those payments get made. There's going to be performance obligations, things you have to do in order for those payments to be made. There could be termination provisions that specifically speak to how the agreement can come to an end, in addition to the time for that agreement expiring, and in addition to a breach of that agreement. And then lastly, there might be a force majeure provision, which is a concept that my colleague Arif will be speaking about in a few minutes. You might also see some provisions in your sponsorship agreement that relate to other kind of promises that you're going to do, either a morality clause, that you're not going to engage in certain conduct that would reflect poorly on the brand, certain basic statements that you make about yourself as an athlete that you say are true, that's called a representation or a warranty, or your sponsor might make a similar sort of statement to you. Those are going to be probably fewer in your sponsorship agreement than you would see in other agreements, but they still might be there. So another example of a provision would be either a signing bonus or a initial payment that is, actually, could you please go back to the other slide? Thank you. A signing bonus or provision or an initial payment provision that has a condition attached to when you would receive those funds. This is a bare bones sort of example that we could have a one-time contract bonus upon a certain date and the use of the sponsor's equipment or products during the Summer Olympics. So that one is an example where there's a condition that in this current situation may not be possible to actually be satisfied. This is where I have to emphasize for each of you that the exact specific wording of your sponsorship agreement that you have with your sponsor is going to determine whether or not it's enforceable, whether or not it's something that can still happen, or whether or not there is a potential for that agreement to have been frustrated or to be impossible to complete or substantially different in terms of what its completion would mean, which are the concepts of force majeure and frustration that Arif is going to talk about. So in this example, can the sponsor refuse to pay a signing bonus? Well, unfortunately, we're aware that there's not going to be a 2020 Summer Olympics. So it's definitely a point in question. And the precise answer to that would probably come out of what other provisions in that contract say. Next slide, please. This is an example of a contract with installment payments being provided for. So you've got two different dates. Installments mean you can get paid purely based on dates passing by, or certain events having passed by. So this is an example using just straight dates. Installment payment might come after your event has been completed, or after the trigger, your performance is completed. So in this situation, if you have some obligation to perform, say wear a logo at a specific client, a sponsor-specific logo at a specific event, and that's not possible because that event has been canceled this year, then again, you're back to the question of, is performance still possible? And there's a question of whether or not the sponsor can claw back any advances. Again, that answer is going to depend on the specific provisions elsewhere in your agreement, but typically, unless there's something that says they can claw back that prior payment, it's unlikely that they're going to have a clear right to do so. Next slide, please. This is another couple examples of where your performance might have been required to be one thing, but in light of COVID, it's not clear what can happen. So if you're supposed to wear a certain logo during participation in all events during the 2020 season, well, arguably there's still a 2020 season, but there's no events, or maybe there's only a limited number of events that are going to take place. So this is another example of where performance has been made more difficult, or perhaps doesn't mean the same thing as the parties originally intended. But maybe performance in a little more limited capacity is still possible. And then there's something like the second example there in italics, which is that the athlete is required to post to social media certain number of posts referring to the sponsor during a certain period of time. Now, strictly written as it is there, that's something that you could still do. That's not specific Olympic dependent. That's not requiring you to participate in a specific competition. So if you can perform that obligation still, then the next question is there something in your contract that says that the sponsor might be able to get out of its obligation to pay? And that idea of impossibility or force majeure can apply to your sponsor as well as to you. Next slide, please. So again, contracts come to an end when performance has been completed by both parties. If there's been a breach of the contract, there might be specific provisions in your contract that say how you can get out of that sponsorship or how the sponsor can. There might be a specific termination provision that says in these specific circumstances, the contract can come into an end on notice by your sponsor or by notice by you to the other party. Force majeure can sometimes lead to termination of a contract or frustration. Next slide, please. This is an example of a termination provision where it's at the option of the sponsor, because if the athlete participates in an event that covers up the logo of the sponsor, then the sponsor can renege on the agreement and terminate and no further payments will be made. So this is an example that has a specific event, requires strict compliance with the preconditions for termination. So that exact event has to happen before the sponsor can use this provision to stop making payments. And depending on how these are worded, they might be too narrow to really allow the sponsor to get out of that obligation just because COVID-19 has generally affected sport. Next slide, please. So now I'm going to turn it over to Arif, who's going to talk about the other two ways that your contract might not be able to move forward and operate: force majeure and frustration.
Thanks, Julia. As discussed, I'm going to review two ways that a contract might be ended: force majeure, and then secondly, frustration. Now, it's important to remember that parties tend to look at these when they want to end a contract, but the contract might not provide an express exit. This typically arises when there's a downturn in the economy, and that might be the case as we see it now with COVID-19. Next slide, please. So force majeure is a clause found in an agreement that excuses performance due to some sort of supervening event. That could be an act of God, the breakout of war, and in today's case, perhaps a pandemic. Now, normally a force majeure provision will expressly state how it's triggered, how to give notice to rely on it, and what relief it provides. Next slide, please. There is a similar provision under the Quebec Civil Code, and in that case, in the case of Article 1470, it does not have to be specifically written into the agreement, but it still can be applicable. Next slide, please. But in the majority of cases, a force majeure provision will be express and it will state how it operates within the wording of the contract. Next slide, please. If you are concerned about a force majeure clause within a sponsorship agreement you're party to, read it and think about four things. Has the clause been triggered by its own language? Are you affected by the triggering event? Or is your sponsor affected? If you want to rely on that provision to end an agreement or possibly suspend it, who do you have to notify? How do you notify them? And how quickly do you have to do so? But probably most importantly, think about what the result would be. Next slide, please. Now, this is language I've taken from a major international sponsor from a real sponsorship agreement. You'll see that in this clause, if there's a force majeure event, the sponsor can extend the contract for an equivalent amount of time without compensation to the athlete. However, if the event continues beyond 30 days, either party can elect to terminate the sponsorship. If this is something that might be applicable to you, in deciding what to do, you need to be strategic and think about what you hope to achieve. Think about the desired outcome. A sponsorship might be something that might be too onerous during the present circumstance, and you might want to move on, try to renegotiate or look to a different sponsor. It might be a circumstance where your sponsor is looking to save costs in the short term and possibly don't want to pay. Are you okay with that? Or you might simply want to extend the term and keep the relationship going, looking to better times ahead. Next slide, please. If you think you want to rely on a force majeure provision, it's crucial to follow the notice requirements. That's one important thing to remember as well. And the same applies to your sponsor. It's crucial that if they want to rely on it, they have to give you proper notice. So in the present circumstances, does COVID-19 trigger your force majeure clause or Article 1470 of the Quebec Civil Code? That will depend. If you are still concerned or if you are still contemplating exercising that clause, have your contract read by legal counsel. Next slide, please. The second method to end an agreement I'm going to talk about is called the doctrine of frustration. Next slide, please. It's another way that a contract can be terminated by an unforeseen event which is external to the parties. It's important to remember that it must be an event that makes performance radically different from the original agreement. Next slide, please. Frustration requires a very high threshold. It's not just that performance becomes difficult. Performance must essentially become impossible. Whether frustration applies is a very specific analysis into your circumstances. Next slide, please. But I'll give you an example from the case law that might help clarify the requirement. So in this example, a pizzeria leased a space in a strip mall. Part of that lease required the pizzeria to provide heating to its neighboring premises. Things went terribly wrong and the pizzeria burnt down. In that case, does the pizzeria have an obligation to keep providing heat to the neighbor? The court said yes, it does. The neighbor had been able to install its own heating at a cost of $20,000, which the pizzeria could have done or paid for. Therefore, providing heat was not technically impossible, so frustration did not apply. Next slide, please. If we consider the example of a concert canceled due to safety problems at the venue, there could be an argument for frustration. Similarly, frustration might apply if sponsorship is contingent on qualifying for a certain event, if that event has been canceled. However, if your sponsorship agreement simply requires you to wear a particular brand at public appearances, maybe there is no frustration. Next slide, please. So again, frustration is specific and it depends on the particular requirements of your contract and your individual circumstances. If you want to consider in more detail, in either case, whether it's force majeure or frustration, whether you can end an agreement or whether your sponsor is within their rights to end an agreement due to COVID-19, have your contract reviewed with the assistance of legal counsel. Next slide, please. And I'll turn it back to Julia.
Thank you, Arif. Next slide, please. So we're going to talk about two ways you can move forward without your contract being terminated. One is that you can potentially still perform under the agreement. Perhaps not all aspects of the agreement can still be performed, but some still can, and you can get remuneration for that. And secondly is talking to your sponsor and agreeing to an amendment. Next slide. So performance. You should consider, as Arif just was mentioning, what can both parties still do? Many contracts do have some provision anticipating partial performance, delayed performance, modified performance, or reduced performance, and what some of the consequences might be, like potentially payments are scaled based on certain performance. Your specific contract terms will vary contract to contract. And so it really is important, like as Ruth was saying, to look at your individual agreements. Depending on what those exact wordings are, your obligations or your sponsor's obligations may or may not have changed. So for example, thank you, next slide. So for example, if you're required to make a certain number of posts over a certain period of time on social media, referencing the sponsor and using their logo in the picture, that's something that is something you can still perform. You can still fulfill your obligation. So you do want to look at the exact wording and make sure your sponsor is still obligated to pay you in return. Next slide. This is just a quick note, and we're going to skip past the next slide after this. You might be concerned that you've been paid already a bit from your sponsor, and now you're not able to perform, and are they going to penalize you for that? Well, the concept of a penalty is generally not going to be applicable in the case of a sponsorship agreement. That's something that wouldn't really come up just because you're not able to perform. And in any case, true penalties are not really valid in Canadian law. Instead, only an estimation of damages, that is the loss suffered by the other party, is the only thing that really can be enforced in a contract. Next slide. And we're going to skip past that one as well, thank you. So your best strategy going forward, do you need to amend your agreement? So amendment is a type of variation. It's essentially a new agreement. So you have to have a consensus between you and your sponsor about what the new terms are going to be. It can be, in fact, just a minor variation on the existing agreement, but it's still something where you have to agree all over again. And that can lead to a variation of your contract. So you need to have that agreement be established. It can be implied or express, but caution to everyone out there who has a casual conversation with a sponsor, if you don't have your agreement, your amendment to your sponsorship in writing, it causes a lot of issues, including whether or not come time for payment, your sponsor actually agrees that they did amend the terms, that you still have an agreement, and what your obligations are. Once you do have an amendment, however, the new terms are what you all have to abide by, not the old terms, even if circumstances change and you regret the amendment. Next slide. So looking at your potential negotiations with your sponsor, consider, do both you and the sponsor still want to maintain the relationship? Can the terms of the existing agreement be modified to give you both some value in the current season? Or is it something that the term just needs to be extended until future events can take place? Do you want to just push out that end date of that agreement so that more sport events can take place and you both get value? And you also might want to consider what happens if there are further event cancellations, delays, and impacts on the sporting events that you're normally going to be representing that sponsor at. It's also important to keep in mind that both the World Trade Organization, the World Bank, the US government, all indicators indicate that we're not only in a recession right now, but we're potentially in the worst world recession since the Great Depression. So it's worth taking a moment to think of things from your sponsor side. Most companies right now in a variety of industries are very cash conscious. They're looking at their marketing dollars very carefully. And that means that when you approach them, you need to have a good sense of what value you continue to bring and what value you can potentially add to that relationship so that they can also be presented with the value that you see in your relationship from your side, and they can use that to convince their internal teams and their internal stakeholders that investing in you and in sport is still worth their time and money. Next slide, please. And lastly, as Arif has said, your specific agreement depends on the specific words in that agreement. So getting some legal counsel before you go speak to your sponsor is not a bad idea. In fact, we would suggest that's the best way to proceed. And that means you're also armed with knowledge of what your sponsor is still obligated to do. Potentially, they're already still obligated to keep paying you. And you going to them and having that negotiation means you'll know what your bargaining position is and what their bargaining position is and what your desired outcomes are. Erin?
Thank you, Julia. I'm going to finish off by just briefly discussing what comes next. And what we've learned with throughout this pandemic and over the last 9 weeks is that every day something new happens. And often we find out about it when the Prime Minister makes an announcement, speaking moistly from the steps in front of his house. And so it is, I think it's frustrating for people because I can imagine how anxious everyone is. And then you hear about different funds that are being offered, but no details are given at that time as to how that money is going to be allocated. And a perfect example of that is the announcement that was made last week. And so we had already heard that there was going to be $500 million given in an emergency support fund for culture, heritage, and sport organizations. A little more information was provided on Friday that this fund is going to be administered by Canadian Heritage, and $72 million is going to be designated towards sports organizations. And that's going to be broken up into different buckets. So $34.5 million will go to the NSOs and different sports institutes. $32.5 million will go to provinces and territories so that they can work with the various sport organizations. And then $5 million will go to the Athlete Assistance Program. Now, we don't have much more information other than that at this time. We do know that they have said that the criteria for being eligible for this funding will be similar to the criteria used with the other programs. And so they have put some things out, the government has put out some information on its website saying that this money is going to go towards organizations that are in need of support because they have lost revenue or income as a result of the pandemic, and that their intent is to continue operating so that they will continue to operate after the crisis resolves. And then they've also talked about the fact that you can't be seeking money from multiple different sources to cover the same thing. So for example, if athletes are eligible for CERB, then they wouldn't be eligible for this additional portion of the additional money through the Athlete Assistance Program. Or if a company is getting wage subsidies, then employees wouldn't also be eligible for additional funds on top of that. So, and then the last thing that they have said is that some of the funds at least will go directly to workers. And so in this case, in the case of sport organizations, that could be people who are working for sport organizations, and it could also mean athletes. So we know that this funding is out there. The government has indicated that they want to distribute it quickly, and that the sport funding in particular is going to be part of phase 1. So I expect that more information will be available on that in the coming days. And again, like everything COVID related, things are evolving very quickly. So it's just a matter of staying tuned to see what comes next. The other thing that I'm sure is top of mind for all of you is about training and what is happening in terms of where you're training now and where you're going to be able to train. Certainly a lot of your sports organizations have put out guidance on this already. Because of the restrictions across various provinces, it's been very limited as to where you're able to train. And I took an example from Athletics Canada. They have on their website that they're still encouraging people to train in isolation at home. And then they also offer suggestions for those who are looking to train in outdoor spaces. Again, this is going to depend on provinces. Ontario has just announced that it is opening some of its outdoor spaces, but other provinces have not reached that level yet. So again, you want to be careful about where you're training. If you are training outside, you're still to be training alone. You're also supposed to keep at least 2 meters social distance between you and anyone else who may be training as well. And they've actually come out with an article that is posted on the Athletics Canada website that suggests that if you are exerting yourself, so anyone who would be running or cycling or things like that, that you should actually be even more than 2 meters apart. So you want to make sure that you're aware of what these requirements are, so that you're able to train safely and within the guidelines established by your sport organization. Things have started to reopen. I'm sure many of you have heard in the news that different provinces have introduced their reopening plans. Many of them are just kind of a framework at this point and don't actually offer any concrete dates. Certainly that's the case in Ontario. British Columbia is ahead of the rest of the country in that they seem to be reopening things sooner. Their cases, new cases, have remained quite low. So they are able to move to that next step. And that province has said that gyms are likely to open after the May long weekend. So that people would be able to get back into training facilities shortly. There will be guidelines that are put into place there. Again, keeping in mind things like social distancing, cleaning and disinfecting machinery or equipment that's used, and things like that. Ontario has just announced that professional sport training facilities were to reopen this week. So, the Raptors have made statements, for example, that some of their basketball players will be back and training. So I imagine it's only a matter of time before your training facilities would open as well. And I know that several organizations, Rugby Canada, Swimming Canada, etc., have all come out with task force that are looking at this issue about this return to play and return to training, return to competing. So this is something, again, where unfortunately there are no set timelines right now, but it is something that we are hoping, to have more information on in the coming days and weeks. And that should give you a little bit more certainty about what comes next. So I wanted to thank you for your attention, and I'm going to turn it over. I know we've had lots of people typing in their questions, so I'll turn it over to Marc-André, who will field the questions for us. Thank you, Marc.
Merci, Erin. Merci à tous. Vous avez été assez actifs au niveau des questions. Thank you all. You have been quite efficient in sending questions. So we'll start first maybe to our two first speakers, David and Raphael. So first question, regarding CERB, say we have a bursary, like HBC bursary, $10,000, but are missing out on prize money, which isn't guaranteed income, would be eligible?
Yeah, so I think there's two parts to that question, and the first, let's deal with the second one first, which is prize money. So this is something that athletes would be anticipating based on performance and based on competitions, and that's no longer available to athletes because seasons have been abridged or canceled altogether. So anticipated income, like prize money that isn't earned, so as the question points out, this is not guaranteed income. Income that isn't earned doesn't knock you out of CERB. So in other words, you could be eligible for CERB, and the fact that you would have earned prize money doesn't knock that out. Now, bursaries, whether bursaries are considered employment income or self-employment income, I can't answer that directly myself. It would depend on the term of the grant, the particular grant. But if it's equivalent to the AAP or karting income, I think there's a good likelihood that a bursary is not going to be considered employment income, such that it will knock you out of the CERB.
Merci, David. Autre question, à nouveau, David ou Raphaël. Are we eligible for CERB if we have a sponsorship contracts, but none of our payments fall under the months of CERB? Example, one payment a year or biannual payment, missing possible prizes money during COVID?
Yeah, so I'll handle that one too, Marc-Andre. I think that's a good question. The first thing you'll want to make sure is look to your contract to ensure that the payment period is not covered during a period of time that you are in receipt of CERB benefits. So, but if you're in a winter sport and your sponsorship is time limited to that period of time, and that income is not earned or paid during the time that you're in receipt of CERB benefits, again, it should not prevent you from receiving those benefits because you have not earned that income at a time when you're in receipt of benefits.
Thank you. Question. This one, maybe David or Arif. I was working for a federation and was laid off March 23rd due to COVID-19. And then I applied for EL. EL rolled into CERB. However, I still have to fill out my EL reporting earnings. Am I able to earn $1,000 a month through, or do I have penalties?
Yeah, I'll handle that one. So I think it depends on, it's a timing of the period, right? So remember that these benefits are broken down into 4-week periods. And so the question of whether you're over the threshold is a by-period question. So, and this has happened to hundreds of thousands of employees across Canada. They continued working into April, and then they lost their job in April. So they may not be eligible for CERB benefits for the March period, but April and into May and into June, they will be eligible. So I think that answers your question. You break it down for the period that you're applying in. So you may not be eligible for the first period, but for subsequent periods you are.
Another question, David. Are athletes who seek sponsorship considered self-employed? If so, given the pandemic's limitation on ability to seek new sponsorship, are we considered out of work?
Yeah, that's a good question. My understanding is that sponsorship income is considered self-employment income, and like anyone who is unable to access employment income, whether it's your own employment or through your employer, you are eligible for CERB if you meet the thresholds.
Arif, question for you. If my sponsor looks like going insolvent, do I have any remedy?
Practically speaking, you would be what's called an unsecured creditor. An unsecured creditor has very limited rights and is unlikely to recover from an insolvency. Your best bet, if you think your sponsor is going insolvent, is to try to get payment sooner than later. That's all you could really do to get the cash in hand.
Thank you. We have additional questions that have come in, so I will read it again. So, will there be additional funding available through AAP? If so, will I be eligible if I have been receiving CERB? Or is that information not available yet? Is that for you, Aaron?
Sure. Thank you, Marc-Andre. The information isn't available yet. It does look like there is going to be $5 million of the $72 million that was dedicated towards sport. It looks like $5 million of that is going to go to AAP. We're not sure what that exactly will look like. So that's the first part of the question. The second part of the question is whether or not you would be ineligible to collect that if you were collecting CERB. And again, we don't have that information. They have said on their website that the intent is not to allow people to double dip. So if the AAP funding is to compensate for lost wages or lost income, then it's likely that you would not be eligible if you have been collecting CERB. But if AAP is to compensate for other things, such as costs associated with training, greater lost income that would go in and above what it would be for CERB or to pay for future travel or events, then you may still be eligible. But we just, unfortunately, right now, we don't have a lot of information beyond that.
Thank you, Aaron. Another question for the CSB. How do I show that I'm seeking work? And do I have to be a full-time student? Is that for you, David?
Sure. You do not need to, you need to be registered in a program, so you don't need to be a full-time student necessarily. As far as confirming that you're looking for work, it requires the applicants to make affirmations through the program that they are looking for work. It's similar to other governmental programs where recipients are required to look for work. So you need to, in good faith, continue to apply for positions. But it's a fairly, if it's like other government programs, and I don't know the specific answer to this, but I expect it's a fairly minimal threshold to say that you're looking for work, but you do have to engage in that. You do have to affirm that that's what you're doing.
Another question. Last season, I did everything necessary to receive a carding in June. Due to the pandemic, the carding process is retarded of 4 months in short track speed skating. Am I eligible to any support?
Yeah, Florence, I think you are. The carding income won't impact on CERB, whether you receive it or not. So if you're not in receipt of that income, then you will be eligible for CERB, or if you're a student, potentially CESB. But CERB is designed as the primary vehicle for people that are out of work to receive government benefits.
Another question. Would I be eligible for CERB if I was supposed to have a fundraiser event to help pay for my season, but due to COVID, it isn't going to happen?
Yeah, so that's kind of like the prize money question. So it's anticipated income that didn't come in. So you're kind of like the bartender who's waiting for the hot summer season on the patio, but you're not going to make those earnings that year. So it's income that you haven't earned, and you will be eligible for CERB because effectively you're out of work, you haven't got that income.
Another question here. As a landlord, does my tenant's rent count towards income whilst I am collecting EL CERB?
I would defer to Arif, but my understanding is that being a landlord, income from your tenants counts as employment income, and so you do need to claim it as you do on your taxes, and that could disentitle you or claw back part of your CERB benefit.
And David, actually, I'll jump in here for a moment as well. So you're right that if you are a landlord and you are collecting rent, then it is considered income. However, if you, for example, have roommates and you collect rent and then would pay, and they pay you a portion of the rent, and then you turn around and pay it to the landlord, so it's more of a flow-through amount, then that expense wouldn't be considered income. So it's only amounts that would be over and above, if you're in that kind of communal living situation, or shared workout space or things like that, it would be only amounts that were over and above the actual cost that would be considered income that you would then have to turn around and declare.
Thank you, Aaron. Other question. If you invoiced your sponsor in early March and they paid you early April, would that make you ineligible for the first CERB payment? Who does want to answer that amongst our colleagues?
So,
go ahead, Aaron.
Okay, I was going to say,
Fight.
yeah. If you the income is attributed to the period for which it's earned rather than the period for which it's paid. So again, depending on what your invoice, what period of time your invoice was for, and that will depend on whether or not you're eligible. So if you've invoiced them in March and that was for services from January through March, for example, but you're not paid until April, then that's income that's attributed to the January to March period rather than to April. But if you're invoicing them in advance for services that are to come, and you're paid in March and it's for services in March, then you would be ineligible, assuming it's over the $1,000 threshold.
Another question. What would you suggest for athletes who are currently receiving AAP funding? Should we apply for CERB, or should we wait for more clarity on potential APP funding addition?
Well, I think the answer to that is a very personal answer, and it depends on your personal circumstances. These programs are designed to support people who are unable to earn income as a result of the pandemic, and that's affecting athletes as it is many other members of society. So, you know, I think it depends on your situation and on your need. The programs, if you're eligible for them, you can receive payment relatively quickly. So that's my non-answer to your specific question.
Another question. I'm only 16, never worked before, and too young for the student program. Does that still makes me eligible?
For CERB, the fact that you haven't earned income in a previous year is problematic. So you may not be eligible for CERB because you don't meet that $5,000 in the previous year threshold. If you're not a post-secondary student as well, you may not have eligibility for CESB. So unfortunately, the answer to those questions may be no, you're not eligible for either program.
In the same vein, David, if you could qualify for either CERB or CESB, is there one better than the other?
I think, well, the monetary benefit of CERB is higher. It's a $2,000 payment per month as opposed to $1,250. So from that aspect, CERB is higher, and it's not really framed this way, but CESB, so the student benefit is for those people that are not eligible for CERB. So my answer would be you're probably better to apply for CERB if you're eligible.
Can you confirm again that if I receive Sport Canada funding of $4,000, I do qualify for CERB?
So again, this is, and if Tom Hall is able to come in, that is my understanding, but that's information that Sport Canada has provided, that AAP funding is not eligible. Now that level of $4,000 is, I'm not sure if that's typical AAP funding or not. So I'm sorry, I'm not an expert on that particular program. So I'm not sure if other participants can speak to that.
Quickly on AAP, it's a living and training allowance and is not considered income. And it's a grant from Sport Canada that's not considered income. So if that's all you made in the previous year and you didn't file any taxes, then you would not be eligible. And it should not interfere with any applications this year if you are eligible.
So our time has expired for the question period. I thank you for your participation on behalf, once again, of the Fasken team. We were delighted to offer you that session today. Nous sommes extrêmement heureux de pouvoir travailler conjointement avec vous et de vous avoir offert cette session d'information qui, espérons-le, a pu vous permettre de mieux comprendre les différentes propositions qui sont faites, notamment par le gouvernement fédéral, et les conséquences de la pandémie quant au contrat que vous avez avec vos sponsors. Alors, portez-vous bien surtout, keep safe and healthy. This country is counting on all of you. Le pays compte sur vous tous. Tom, to you.
Yes, perfect. Merci, Marc-André, et tout le monde de Fasken. Thank you, everyone, for that from Fasken. That was wonderful. This is complicated stuff, obviously, and we're really appreciative that we could have your help today decoding some of what's been announced. Just to follow up on a few points for everyone. So we are working with the Minister of Heritage, Minister Guilbeault's office, to ensure that NSOs that are RCAAA RCAAAs are covered by the support. So that is something that's ongoing. And also regarding the AAP and the additional $5 million, we are also doing our best to get an idea of what that's going to look like and what that support will be like. My understanding of it currently, and this is not official, is that it is going to be able to help people. It's not to replace income, so it shouldn't interfere. It's really to, if people had to suddenly move back across Canada or had some expenses related to COVID-19, it's not about income. And no idea how to apply for any of that yet. Your NSOs will probably know early. And about NSOs, when it comes to training and returning to group training and all the rest of that, your resource is your NSO. I cannot stress that enough. They are working with 7 or 8 sport med doctors across Canada and every province and territory to figure out exactly what we can do and when as athletes and coaches. And so ask your high performance directors or your coaches. Those are the resources. If you, for some reason, don't have access to that, feel free to write to info@mygameplan.ca and we'll try to find an answer for you. But really, your NSO is your resource. And finally, for athletes, these didn't come up, but anyone who has questions about appeals, carding disputes, or any disputes with your NSOs, you do have access to legal aid through Sports Solution, which is a program of Athletes Can. You can Google that and you will find it very quickly, but they are there to help you navigate all those relationships. And then for some other more general questions, through our partnership with Morneau Shepell, we do have an employee family assistance program that does involve some legal advice and could walk you through a couple of areas that came up. And also, we will be compiling all the questions we didn't get to, and we will generate an FAQ for you. And the final point is that starting right now, there's a webinar on sleep and managing sleep and stress hosted by GamePlan. If you want to get access to that, just write us at info@mygameplan.ca. And finally, if you have any other questions that we didn't get to, you can write to us and we'll do our best to answer them. But thank you all so much. And thank you again to Fasken. This is wonderful. And take care, everybody. Thank you. Goodbye.